This class and the upcoming classes would deal delegated legislation. So, as we know, the supreme legislative body in England consists the parliament, and that parliament consists House of Commons and House of Lords. And in United States of America, the Congress, which is the supreme legislative body, consists the Senate and House of Representatives. And in case of India, the supreme legislative body is the Parliament, and it consists the House of People and the Council of States, which are otherwise known as the Lok Sabha and Rajya Sabha. So these bodies in a state are constitutionally and legally empowered to make law, and sometimes these legislative bodies are so busy and they could not find sufficient time due to heavy workload. So they delegated certain lawmaking power to the executive or to the administrative authorities, and such they delegate regarding those enabling and parent acts legislated by the supreme legislative body to be supplied with certain rules, regulations, or circulars, bylaws, or notifications, etc. And such rules, regulations, notifications, circulars, or bylaws are considered as delegated legislation, and such delegation shall be within the very constitutional and legal provisions of that state. So, as we have already discussed regarding the Parliament of England, here there is the supremacy of the Parliament, and in case of USA and India, it is the supremacy of the Constitution. So, the very delegation must conform to the constitutional provisions as provided in United States of America and India. So also in case of England, as the parliament is supreme, so all delegation must conform to the parent and enabling act, and that delegation must be provided in the same parent or enabling act. And delegated legislation sometimes also took different forms, but the very legislation made by the legislation is a kind of original legislation. So, in that context, we could discuss about executive legislation, and that executive legislation is the lawmaking by the head of the executive of a state, as in case of England, the crown, and in case of USA, the president, and in case of India, the president of India, and regarding the provinces of a state, the governors of such states or provinces. So, regarding executive legislation in case of India, Article 123 provides that in case of the parliament is not in session and there is the urgency or necessity of a law, then the president can promulgate ordinances, and by that ordinances, law could be declared or made by the president. But in absence of the two houses of the parliament, and in the same way, Article 213 provides that in a province or in a state where the legislative assembly is not in session, and if there is an urgent need of a piece of law or legislation, the governor is empowered by the Constitution of India to promulgate ordinances, and by this way, the executive or the head of the state or the provinces can make original legislation. So, here, executive legislation is a kind of original legislation and it is not delegated legislation.